Okay, so I want to go back to January 22nd and look at day 19 in the Young Thug YSL RICO trial. Now, you may have heard me talk about it already, but there's a kind of ridiculous plea agreement that was signed in this case. On the stand here currently, on the left-hand side, you see witness Trontavious Stevens. He is a prosecution witness, and he took a plea deal to cooperate with testimony in this case. He was held for 7 months. He actually says it was 9 months. His bond was denied, and then in December of 2022, this plea agreement shows up, and if he signs it, he can get up on out of there. Now, the most questionable part about it is this language here. Defendant cannot truthfully assert that anyone charged in this indictment is not guilty of the crimes as alleged in this indictment, and defendant will make no attempt at trial, prior to trial, or after trial to exonerate or exculpate anyone charged in this indictment of the crimes alleged in this indictment. Defendant will not claim that anyone on this indictment is not guilty of the crimes as charged in this indictment. So right there, this is a plea deal. One of the criteria is that he's got to cooperate and come testify in this RICO trial, and there's multiple defendants that are on the line here. So what Trontavious Stevens signed to in this plea deal is he'll make no attempt at trial, prior to trial, or after trial. He cannot truthfully assert that anyone charged here in this whole trial is not guilty as charged. That's insane to me. And even if this was the only means by which someone can secure a conviction against someone who's actually guilty, I'm still not sure how I'd feel about this being the strategy to do so. This looks like something that could get a lot of innocent people wrongly convicted because it's securing testimony of a witness who cannot testify truthfully. But a witness should be there. They take an oath to testify truthfully. And the prosecution is using this language that kind of constrains them otherwise. Let's see what Attorney Matthews comes up and asks Trontavious Stevens about this plea deal on cross-examination.
Mr. Stevens, good afternoon, sir.
Good afternoon.
You testified that you had a job before you actually turned yourself in back in May of 2022 on these charges, correct?
And that's important. So he has a job. Trontavious Stevens has a job, and then he willfully turns himself in on other charges that he was charged with back in May of 2022. So the idea there is you probably had a job that you thought you'd get right back out to, and that's why you're going to ask for this bond, and you're probably going to be shocked and disappointed and not ready for it when that bond is denied.
Yeah.
Okay. And you voluntarily surrendered yourself to the Fulton County Jail, correct?
Yes.
And when you were in that jail, you filed a motion for bond through your attorney, correct?
Yes.
But when you were in that jail, you didn't have a lot of choices in terms of how you could live your life when you were in that jail, in terms of what you ate, correct? What time to go to bed, correct?
Yes.
Using a cell phone, using a legal cell phone, correct?
Correct.
Taking a drive, correct?
You know what to drive?
Seeing your children.
Yeah.
All the things that in the free world we could do, correct?
Yes.
Now, all of this is establishing that, any reasonable person would not want to be stuck incarcerated.
Right. Now, your lawyers filed a motion for bond on your behalf, right?
Yes.
And there's at least one or two motions for bond that was filed, right?
Yes.
At least one or two motions for bond were filed. They were all going to be denied.
Yes.
And when your lawyers filed that motion for bond for you, they told the court that you had turned yourself in, correct?
Yes.
They told the court that you had entered a plea back in 2015, correct?
Yes.
And that you'd done your time, right?
Yes.
They told the court that you had...
I object to getting in with lawyers.
What's the basis now? Okay, all right.
Oh, thank you.
So I think and this is not the first time in this trial by any means that the prosecution tries to give an objection, and then the judge is like, what's the grounds for your objection? And then they're just like, so the judge just overrules the objection because there's no basis given.
Mr. Stevens, you remember the last question?
Can you go again?
Okay. Your lawyers told the court that you were working, correct?
Yes.
They told the court that you had voluntarily submitted yourself to the jail.
Yes.
They told the court that you had children, right?
Yes.
They told the court that you had not been in any new charges or any new arrests since the 2015 when you took your plea, right?
Right.
That was all true, correct?
Yes.
You were living your life, correct?
Yes.
You were doing the things that were lawful and abiding in terms of the law, right?
Right.
And then you got indicted on these charges, right?
Yes.
And when your lawyer told the court all these great things about you to get you a bond, the district attorney's office, these people right here, they told the court that you were a flight risk, correct?
I'm going to object
Basis.
to relevance.
I sustain the objection.
Should you go see interest?
I sustain the question.
Okay. You can rephrase the question?
Yeah, you can.
Thank you. Mr. Stevens.
Hey, my bad. You asked me a question.
Well, I'm going to move
Not a
to.
question pending, sir, so he's going to ask you another.
seems like he really wants to say something. Probably like, yeah, they kept denying my bond. I don't know what actually he would have said, but it seems like it relates to the last question that wasn't finished being asked.
Right?
Oh, he had one further.
Okay.
I want to answer it. Right. Go ahead.
Okay. So, Mr. Stevens, when you were asking for that bond that we just got through talking about, the district attorney's office, they didn't want you to get a bond, correct?
Yes.
They wanted you to remain in jail, correct?
Yes.
And their wishes were met. Your bond was denied, wasn't it?
Yes.
And you continued to sit in jail for that period of time, correct?
Yes.
You sat in the jail for many days after that, right?
Yes.
Many weeks after that, right?
Yes.
And some months, right?
Yes.
And during that period of time, you were scratching your head trying to figure out how it was that you couldn't get a bond, right?
Objection, Your Honor. One vote is in.
Point out. I sustain the objection. It's a formal question.
Now, Mr. Stevens, you could not get out of jail, and then at some point, this 16U, this plea agreement came forth, right?
Yes.
And 16U that the jury just heard me talking about, you initialed those various paragraphs in each one of those pages, right?
Yes.
And I want to take you directly to 16U to paragraph 14 in the factual acknowledgments. Can we go there?
Yes.
Now, in paragraph 14 of factual acknowledgments, it states that defendant cannot truthfully assert that anyone charged in this indictment is not guilty of the crimes as alleged in this indictment, and defendant, you're the defendant that's in this document, right?
Yeah.
That you, the defendant, Trontavious Stevens, will make no attempt at trial, prior to trial, or after trial, to exonerate or exculpate anyone charged in this indictment of the crimes alleged in this indictment, and that defendant, still being you, Trontavious Stevens, will not claim that anyone on this indictment is not guilty of the crimes as charged in this indictment. Those were not your words, right?
Correct.
In your own mind, when you reflect on that paragraph 14, what does that paragraph 14 mean to you, that saying?
I can't say nobody guilty or not guilty.
That you can't come into
So they ask him what that means to him, and he responds, I can't say anybody is guilty or not guilty. But he's here to testify about whatever he has knowledge of these counts that are being alleged against a defendant, multiple defendants, whatever. So if he can't say anybody is innocent or guilty of the counts being charged here, how credible is his testimony? And like, let me know what you think if, you saw his face a little bit. I tried to pull the screen down a little bit. What do you think about him sitting there, like, having this read out loud in front of him? What might be going through his head?
this courtroom, and that you can't come into this courtroom and say to this jury that anyone in this courtroom, anyone that's sitting in this courtroom as a defendant, you cannot tell this jury, even if you knew that they were not guilty.
I sustain the objection.
You can't come into this courtroom, Mr. Stevens, and you're not allowed, you're prevented from saying that anyone who's charged is not guilty, correct?
Yes.
And that paragraph says that you cannot truthfully say it, even if you want to say it, correct?
Yes.
I think that's great questioning by the defense attorney, in case the jury missed one or two times or missed the reading of it. Because again, they didn't have this text in front of them. We were looking at it. We're paying attention to this video right here. But the jury, if they didn't catch that, the defense attorney here, Defense Attorney Matthews, has reiterated, you cannot testify truthfully. You cannot truthfully assert. Just getting that out there, making it clear and known and heard.
And you cannot claim that anyone is not guilty, correct?
Yeah.
You can't do it before this trial ever started, right?
Right.
You can't come in here now and say it, correct? And when you leave, even after this trial is over, you can't even come back later and say
Ever.
that anyone was not guilty who sits in this courtroom, correct?
Yes.
As defendants. And then you sign the plea agreement, right?
Right.
And when the same district attorney's office, when they said to you that you couldn't get out for a bond, this same district attorney's office came to you and told you that you could get out if you took a plea, correct?
Yeah.
They said, Hold on. Actually, let's circle back. You want to get out, right? You know, here's something that could help you get out.
And that was within a span of you being in custody for 7 months, right?
9, yeah.
9 months. Is it fair to say that they no longer thought that you didn't meet the conditions?
Objection, Your Honor.
They just,
Stipulation.
I sustain the objection.
now, changing gears, Mr. Stevens, you testified earlier that, just 1 second, Your Honor.
Yes, sir.
Then, just like all of the other defense attorneys that had questions for this witness, he's going to go into a line of questioning about, you didn't really know my client that well, did you? Like, you weren't doing anything organized with him, right? But with that being said, what do you guys think about, in general? Let's step back. What do you guys think about specifically in this case? This is a RICO trial. There are multiple defendants in trial here. There are multiple plea deals involved in this trial, in this case. This is the text of one of them that we've poked into right here on this video. This defense attorney has hammered down on it. I don't know the text of the other plea agreements that were offered to others in exchange for their testimony or cooperation in this case. But with this one right here and this just one witness, how important or impactful do you think this is? Then, more broadly, what do you think about a prosecutor offering a plea deal with language like this in it? What do you think of, potential other cases where, especially a he said, she said type of situation where there might not be other types of forensic evidence, where testimony is really the crux of the case. The crux is what builds the prosecution's argument. What if that testimony is secured from a witness through a plea deal like this, or any other type of benefits conferred to the witness? In the United States, the defendant has a right to a fair trial. There's all types of state and federal rules that are supposed to help make sure that the defendant has a fair trial. There's evidence rules, there's witness rules, there's Brady disclosures. But as a juror sitting in the jury box, you don't always get to hear about stuff like this that might go on. In the Jonathan Majors trial, we saw over and over objection after objection that was sustained, trying to get the knowledge in front of the jury that Grace Jabari was also arrested for third-degree domestic assault and criminal mischief against Jonathan Majors. The jury did not see those injuries. The jury was not able to know that the district attorney offered Grace Jabari no legal repercussions whatsoever because she's decided to cooperate and testify in their case against Jonathan Majors. In this case, we're getting a peek at it. And this is a long trial. It's hard to say whether jurors are going to lock in on it, take it all in, if it's really going to make a difference in the end, because this isn't the only witness, this isn't the only evidence. But at the same time, we have multiple defendants with multiple attorneys. We have tons of eyes on this case. It's being live streamed. And as I think about it, all I can think about is not every case gets this type of scrutiny. Not every defendant has someone that is aware of the plea agreements offered and the language used in a plea agreement offered to a key witness against them. And I just think this is a huge problem for transparency. I think it's a huge problem for any defendant's right to a fair trial. I think this is a ridiculous ass plea deal language right here on the screen. But now the floor is yours. Get in the comment section. Tell me what you think about, this case specifically, this specific plea deal language. And let me know your thoughts if you have them on prosecutor strategy in general when it comes to benefits conferred to a potential key witness that needs to give testimony in a trial that will help them prove their case against a defendant. With that being said, again, shout out to Thugger Daily. They are doing, threads on X with live case updates for every day of trial. This is a very long trial, so I am absolutely not going to be covering it, although I am tuning in when I can. There are a lot of interesting things about it. Even pre-trial, there was a lot of interesting stuff. Because this isn't a federal RICO trial, there's a lot more transparency. There's cameras in the courtroom. It's an interesting thing to get to look at. Nicholas Starro here on my screen has been doing live trial watches. Some days he's catching up late, but he gets to fast forward through the lunch break. So if you want to watch the Young Thug trial with commentary and skip all the court breaks, it's a great channel. He's efficient. He has great commentary and a great accent to listen to. I'll link to his channel in the description below. But until that, again, the floor is yours. Leave your comments. Let me know what you're thinking. And until next time, you guys take care.